something to the effect that it's like running away from the problem. I just feel the need to correct the impression created, because it is true that on many occasions, Kenyans will rush to court with their cases. Somewhere down the road, maybe because of intervening circumstances, they choose to abandon those cases. Yes. So I think it's a very useful strategy to do away with dead cases in our registries, just to set the record straight.
Could I please?
You wish to comment on that?
Yes.
Okay, feel free.
And here I'll start guided by my Lord Judge Majanja. I think a lot of cases, particularly in commercial, are won or lost on applications. So I would agree with you. If somebody goes to court, commercial division, does not get the injunction to stop a bank from realizing the property, and the property is realized, the chances of that person going back to court are almost zero. So you are quite right. It's the procedure in which we invoke to get those dismissals. If we do dismissals summarily, then what they do is they provoke applications for reinstatement. I'm in agreement with dismissals, but we must be with due process. And sometimes I think in a service week, there's a service week, I remember I did a bit of looking at, not really research, but from that service week there were so many dismissals, and the following week there were so many applications for reinstatement. So it's a question of how we do it, and we do it correctly. But at the end of it all, much as we do dismissals, there are still those cases that we must handle.
Okay, I've heard you on that point. Before I ask you the next question, Senior Counsel, I would wish to ask you, how many associates do you have in your law firm?
Currently, because of what we are going through, I have 3 other lawyers.
3 lawyers.
We upscale as depending on the type of engagements we are involved in. I have led teams of up to 30 and 40 lawyers. I upscale depending on the activities. Currently, as of today, I have 3 other lawyers, so we are 4 lawyers.
Okay, thank you.
Yeah.
Senior Counsel, in my view, you put it quite aptly when you said that the most critical of the Chief Justice's role is to be the head of the judiciary. And you must agree with me that the dynamics in leading a team of, say, 10, 20, 50 lawyers is different from the dynamics of leading an institution, an arm of government that has over 5,000 judicial staff, slightly over 500 judicial officers, and about 200 judges. In your experience, or what you have experienced in your legal life, do you think you are well equipped to handle that kind of responsibility?
Yes, Madam Commissioner, as I indicated, the tools you use to manage Safaricom with so many millions of subscribers are the same tools you'll use to manage another company with a fraction of those subscribers. Consequently, we cannot set as a must-have done somebody who has managed, say, 10,000 people to be the only potential CJ. All over the world, Kenya included, we've had CJs who have not had any leadership of an institution. The most pronounced Chief Justice, Professor, is in prior 2010, is Justice Madan. Any Kenyan would remember Justice Madan. Judge Madan was just a judge. Never ever did any administrative work. He became the most pronounced and the most remembered judge in the history of Kenya, closely followed by somebody like Justice Apalu. Justice Apalu was just a judge, and he was appointed a Chief Justice, had not even run a registry of 2 people or 3 people. those two justices served for a period of 2 to 3 years. They left a mark that is everlasting in this country. I do not think, in my humble opinion, that a person who has had an administrative or task force of so many people will make a better Chief Justice than one who has not. And you can check this across the world. But we don't even need to go further. Kenya in itself is a wonderful example. And starting off from the first Chief Justices, and I'm sure here Commissioner Attorney General has a better history than I have of the Chief Justices who are well remembered and who had not ever held any administrative task in this judiciary.
Thank you. Thank you for your response. Now, moving on to the questions that I had. What is the position of a prospective parent in a surrogacy agreement when it comes to rights, parental rights and responsibilities?
Please say that again.
The position of a prospective parent in a surrogacy agreement in respect to the rights, parental rights and responsibilities.
Surrogacy is one of those very decisive topics. I've dealt with it slightly in my dissertation. The difficulty, Commissioner, as you are fully aware, is what rights do you have? All you did was to say enter into a commercial agreement with a young lady that she will carry the kid for you. This young lady midstream decides no, she's not going to give up her child. She's the biological mother. And those surrogacy arrangements, and at the appropriate time I think I'll write a paper or two, are very decisive topics. In America, this has been the subject of raging controversy, which has gone up to the Supreme Court. Because you who gave the mother the money, you feel entitled as of right. But on the other hand, the biological mother feels, and she's perfectly entitled to feel, that this is the womb, the child of her flesh. So what rights are they? That is something that really one cannot be able to define with any accuracy, because for one answer, you get two different answers.
Senior Counsel, our courts have made some determinations around that subject, despite the fact that we do not have a formal legal framework to deal with those agreements.
Correct.
And I would just love to hear from you how, according to the decisions that have emanated from our courts, how, for instance, a prospective parent should go about acquiring the rights and responsibilities of a parent. For instance, how he should go about getting his name registered as a parent, which of course comes along with the rights and responsibilities of a parent.
Why I indicated that for one answer you get two contra answers, I'm aware of the case. Maybe there are more cases than one. I've been requested to give an opinion for purposes of going to the Court of Appeal. So I'll be a bit hesitant to go into it, but definitely what we can say, and here I think, Commissioner, you would agree, that is not the last word. That decision has not been tested at appellate level, and because of the constitutional underpinning of it, in case I were to go on with that brief, I see myself ending at the Supreme Court. So I'll be a bit hesitant to talk about it, but it is really not a last word on that issue.
Very well, Counsel. We can move on to the next question that I have.
Yes.
What are the Bangalore Principles of Judicial Conduct?
The Bangalore Principles, I do remember them. They are 6 in number. And these are for the judges and also for the judiciary. In the sense that judiciary is supposed to craft a code of conduct around those principles. Independence is one of them. I think the next one is impartiality. That is natural. Equality. The fourth would be propriety, how the judge holds himself, because how the judge holds himself in public and in private is so important. Then the next one is integrity, and then competence. And to me, if I could pause there, Commissioner, competence becomes so important, because to have a judicial officer who is incompetent is to put an aircraft in the hands of an unqualified person. And then the last one, I believe, is diligence. Diligence, and judiciary, and for that matter, JSC, would be able to craft a code of conduct around those principles, as I understood the paper that I read.
Thank you. You've actually moved on to answer my next question. I was about to ask you what is the legal status of the Bangalore Principles.
Yes.
Maybe you can say something about that.
Yes, the legal status is that really this is something that has been agreed upon, and they are repeated all over, and judiciaries or JSCs are supposed to craft their code of conduct around them.
Thank you. Now that you say you did some reading around this, where and when was the idea of having the principles first conceived?
I think it's got a long history. There was a Harare Convention. Before then, there was a meeting, I think, in the United Kingdom. There appear to have been quite a number of meetings discussing this. I may not put my finger directly to the first one, but I could see this, a lot of engagement. And maybe even after Bangalore, there could be subsequent engagements.
Okay, thank you. This is a question that I have got from your introduction. You talked about being involved in some kind of framework, developing some kind of framework of the disciplinary process at the University of Nairobi when you started off. And I just wanted to ask you, because I imagine in your brief at that time, you may have encountered something to do with the subject of student activism or youth activism. What is your position concerning that?
Activism at that level is naturally expected. Youth activism is a phenomena that any university must expect. I also did a bit of work for our Catholic university. At that time, we had clergy who were in charge, and I had really to take the clergy through a process to tell the clergy, look, please remember the students are secular. They are not part of us. They are not part of the clergy. So it is something that we must expect. We can't expect anything less than youth at that level having some activism. What I find difficult to understand is how we as a university then react to that by being very insensitive and having disharmony in how we react to it. So a student found, for example, having done ABC, is expelled by one college, but for the same offense, he is reprimanded. You see, the minute, even for us as lawyers, we see disparity in the sanctions we get, you naturally getting counter feelings that no, so and so was favored because his father is rich. So activism, true enough, it was there. And I'm sure even during our times at the university, there was a lot of activism.
Thank you. Thank you very much, Senior Counsel. Now, my next question touches on matters that border on welfare and employee motivation. I'm sure you did quite a bit of preparation when you made up your mind to apply for this position, and even as you were coming for the interview. And in that preparation, I expect you may have interacted with some of the welfare concerns that the members of the judiciary have. Am I correct?
Correct.
Thank you. Now, we have a scenario that is causing a lot of concern, especially amongst the judicial officers. We know that under the Constitution, in terms of post-admission experience, the required experience is 10 years. By the time a member joins the judiciary as a judicial officer, as an RM, resident magistrate, they are required to have about 3 years experience. If he's lucky enough to get promoted at the next interview, but if he is lucky, comes after 3 years, he would be having 6 years experience. By the time he's PM, if he's extremely lucky, he will have close to 10 years experience. When jobs for interview, or rather when jobs for promotion or appointment to the superior courts are advertised, of course the cutoff required experience is 10 years, just as is provided in the Constitution. But you will find this magistrate is still far below the hierarchy of ranks that is required to go through before he can ascend to the High Court. Invariably, members who should be promoted to the High Court will be picked from the Chief Magistrate level. So that by the time you even qualify for consideration, you will have pumped in no less than 18 years in this institution. Yet out there, shortlisting is done based on 10 years post-admission experience. This eventually also brings in another problem when it comes to the pay structure. Because after putting about 18 years in this institution, your level of pay may not necessarily be at the entry level for judges. But you'll have this fellow, maybe from private practice, after having 10 or 11 years experience out there, coming in and objecting to your higher pay. Those are issues we've been grappling with in the institution. So there is that concern that the application of the cutoff post-admission experience is applied discriminatorily. But then again, we have those challenges. Are we going to open it up for RMs to compete with chief magistrates for promotion to the superior courts? How are we going to address that challenge under your leadership? What creative interventions would you come up with that will satisfactorily settle this issue in a way that will be acceptable to all people on both divides?
Again, it's unfortunate this discussion goes insider and outsider. It's so unfortunate because if my view is allowed, I will still go back to the word of merit. I would hate to ever hear a magistrate saying, if lucky enough, I was promoted. I would actually be doubly hurt to hear the phrase, if I'm extremely lucky, then I'm promoted. My promotion policy would be based on nothing but merit. Merit would be the only consideration, not luck. Consequently, it's important really that a peer review is in place so that a magistrate at court this and a magistrate at court that, this other one, you are able to independently verify how hardworking and meritorious are their output.
I'm sorry, Counsel, if my words sort of created a confusion. When I was talking about luck, I wasn't talking about people getting promoted on the basis of luck.
Okay.
I'm talking about luck in terms of coming up for determination for promotion.
Very well.
Yes.
Thank you. So, because it's merit-based, I would want to see a situation where when a magistrate has done 10 years or 11 years or whatever number of years, that magistrate has an equal opportunity with somebody in private practice to apply for a job, for appointment as a High Court judge. I would not want to hear or to wait until a magistrate is at the level of the chief magistrate to be able to say it's only at that level that you can apply. Because the Constitution defines it's 10 years, isn't it? So why is it we are putting other barriers? Because these barriers become a hindrance only to a segment of the population. For a lawyer, there is no hindrance that you must have done cases up to this level to apply to the High Court. It is the number of years. So, because of this belief I have in uniformity and non-discrimination, I can assure you, Commissioner, in my tenure, a magistrate who has the required constitutional qualification, given the work done, would have an equal opportunity with any other person. As a matter of fact, I'll look more towards magistrates going to the High Court because it's also part of developing a culture of this a reward culture.
Thank you very much, Counsel. I'm sure magistrates listening to you out there are crossing their fingers for you, wishing you luck.
Thank you. Not that I would discriminate against advocates in private practice, but it's important that we do not discriminate against magistrates and then give a leverage to advocates in private practice. We must look at the merit and merit only for these judicial appointments.
Thank you. So now we can move on to your application.
Yes.
I noticed from the documents that, or rather the response we got from the vetting bodies, that you are not cleared by KRA, you are found to be not compliant. I just want to hear from you whether that, whatever issue that was there has been resolved, and if you can get communication to that effect that you have now been cleared.
I think, Commissioners, it's important I say this. Let this process also not have many other actors. I have a valid clearance certificate. Then I got communication from KRA that all candidates for this position must go there. I wondered why we all must go there despite our having clearance certificates. When my tax consultant went, he was told I have some penalties of 1 million shillings. I paid it, but I started seeing as if there is a third hand in this process. A week later, I was told, doing in-depth from 2015, there are some tax arrears. I have responded to it, and I have told Caesar that Caesar, you are entitled to your lawful sums, but nothing more beyond your lawful sum. We have agreed to do an ADR under the Act, and I have every intention to pay whatever is due. But I hesitate to say this. Do not let this process also have any other player. I was quite alarmed about being told to go there despite having a valid clearance certificate. But to answer you directly, yes, we are at ADR, and I've made every provision to pay whatever may be outstanding. For advocates in private practice, we have certain distinct disadvantages. You are holding funds for a client for purchase of a property. The client tells you put that money in a fixed deposit account. Once money is in a fixed deposit account, after 3 months, the interest is generated. And from that interest, there is a withholding tax. That withholding tax is paid directly to KRA. For KRA to assume that the money on interest is your income, and therefore expect me to pay income tax and VAT, you tell them no. It doesn't.